Fight Against Corruption, Lecture 3, Strategic Planning of Fight Against Corruption in Azerbaijan. In our previous lectures, we uncovered the topics of concepts of corruption and the planning of fight against corruption. In this lecture, we're going to introduce the subject, speak a little bit about the Azerbaijani context, touch upon definitions again of the fight of corruption, a summary brief of what we spoke in our previous lectures. Then we will immediately switch to the stages of fight against corruption in Azerbaijan. And the stages of corruption, they include early stage, strategic stage, and so-called post-strategic state. Of course, this is the terminology which I'm using specifically for the purpose of this lecture, as in practice and in official documents there is no such a classification. So this differentiation is conducted solely for the purpose of good understanding and forming the understanding and impression of the fight measures taken in the course of fight against corruption in Azerbaijan, and I will sum it up in the end. So let's start with it. Corruption always takes a public agenda, we know this, and governments, in line with this general trend, they try to adopt targeted measures under the anti-corruption banners. But saying this, we know that there's no definition, there's no settled definition of corruption, and there are only few narrow definitions which are described in documents, especially of international organizations, and you can also find and come across these definitions in the work of prominent researchers and scientists. Of course, the definitions which are used, they are narrow and they do not cover all the scopes and various forms of corruption. So we will try to understand what is meant by this. I mean, what kind of strategic anti-corruption planning is conducted in Azerbaijan in line with what is understood as corruption in our country. And for this end, in order to do this, we will analyze this concept in dynamics and try to understand the concept of it rather than the definition. And in this process, we will see how is it important that how the societal factors are operating in the country and how they define the content of measures aimed against corruption. So if we look at the Azerbaijani concept, we will see that it's the same and in line with the generally accepted position. There's no single definition of corruption in Azerbaijan, although truly in our legislation, in the legislation of Azerbaijan, there is a definition of corruption contained in the Anti-Corruption Act 2004, which we will consider later in the course of this lecture. However, if we take it specifically, we will see that this definition does not encompass the entirety of the measures taken in Azerbaijan in this field. And saying that, it's important to stress that this is a good approach, that this definition contained in the legislation of Azerbaijan does not actually define the content of measures. Otherwise, we would come to the situation where all the measures had to be in line with this definition, as we will see this narrow definition, and it will not let to handle and deal with all types of behavior which we can classify as corruption behavior. We will also look at the concept of corruption in Azerbaijan you will see that it starts in the at the very early stages of developing of statehood in Azerbaijan. Then you will also see as this concept is stretching out and defining at one point of historical development the general framework of fight against not only of fight against corruption but the development of state. And eventually we will see that this process goes a bit back, and the definition, while the understanding of corruption is shrinking, we will see that it also affects the boundaries of and content of measures taken in the fight against corruption. Initially, the process starts with executive orders targeting specific areas and limited to only narrow set of measures, gradually developing and growing to reach the level of strategies. And of course, Azerbaijan is no exception, as we are part of the international community, and we are drawing our inspiration from the achievements and works developed by the international experts community. We are taking the United Nations Convention Against Corruption as the framework. Indeed, as you will see, it will be definitive in the course of developing and formulating anti-corruption measures in a strategic manner. So let us briefly look at the kind of definitions that we have at our disposals. As I mentioned, there are a lot of definitions and there are a lot of concepts developed by scientists and researchers, many of them prominent, and these researchers, of course, affected not only the scientific world, but also the international organizations and the international community in general. But we will limit our scope of these concepts to the definition which you can find in the internet, with the definitions which were developed by prominent international organizations which define actually the development agenda of the entire world, I would say, and which form the understanding of corruption internationally. So the Transparency International defines corruption as abuse of entrusted power for private gain. I repeat, the abuse of entrusted power for private gain. In order to explain this phenomenon, TII, Transparency International, classified it as grand, petty, and political, depending on the amounts of money lost and the sector where it occurs. The next one is the European Bank of Reconstruction and Development. It says that corruption practices mean the bribery of public officials or other persons to gain improper commercial advantage. Although, as you see initially, this EBRD definition aims at compartmenting this corruption, i.e. narrowing it down to commercial advantage, in practice it also refers to the wider definition for compliance and anti-corruption and anti-fraud activities. Explain it as something resulting in the erosion of public confidence in political institutions and legal systems. EBRD directive states that corruption involves the abuse of public or private office for personal gain. Here we see that in this definition, EBRD is coming close to the definition provided by the World Bank, because the World Bank defines corruption as abuse of public office for private gain. The definition, as you see, the definitions of corruption, they hinge on the concepts such as office or power, whether public or private, their abuse, and the purpose of gain. If you look at the literature which has been developed in this field, you will see that it points out that most definitions relate to corruption as a behavior, as a type of behavior of public officials. It points at an illegal act, emphasizes the payment of bribes, and assumes some direct and indirect benefits to one or both parties. And these limitations make it impossible to capture the whole scope of corruption. Of course, I'm referring to a specific word and a piece of research here. But despite this narrow circle, these definitions provide a fulcrum, a starting point to build on, which may lead to a commensurate, adequate understanding of corruption. So, we'll try to move on and see how these definitions, how this understanding and concept defines the stages of anti-corruption efforts in Azerbaijan. Again, as I mentioned in the beginning of our conversation, of our lecture, these stages can be divided into three parts, and these are nominal. This division does not reflect the official position of the government and is conducted only for the purposes of the research. So we will divide it into three stages. The first stage, which encompasses and covers the years from 1991 to 2004. Second stage, which I nominally call the strategic stage, is 2004 to 2015. And the so-called post-strategic stage, it starts in year 2003 and continues up until nowadays. You will see that the stages are clearly divided due to the specific occurrences and processes which took place in Azerbaijan. And as you see, the first stage, it starts with the launching of the early years of independence since 1991. And you'll see that although the modern understanding of corruption locates it as a type of a misconduct of officials, it will gradually grow up to define the general framework of governmental measures aimed at developing the country. So, if we look at the early stage, we will see that it is characterized with a fragile state. Existential challenges existed at this time, and we know that the country faced aggression from a neighbor country. Part of its territory were occupied, and there was an influx of refugees from Armenia and internally displaced persons from region called Nagorno-Karabakh, as well as 7 adjusted regions. Up to 1 million people. They gravely affected the economy and social structure of the state. This also was exacerbated by the challenges such as rampant, serious forms of crime, and usually we had organized criminal groups operating in the country. The proper economy was affected by people who would actually engage in illegal activities. They would make these claims of false entrepreneurship, claim bankruptcy, and after they will take hold of the public funds, they would divert credit supported by state guarantees, which put the state in a more difficult stage. There were groups operating in the country who engaged themselves in racketeering and kidnapping, and of course, quite widely spread in the country were such practices as false auditing and others. In this early stage, we will see that the definitive documents were actually 5 documents. These documents were adopted by the executive orders of the president of the country, adopted in year 1994, 1996, 1998, 1999, and 2000. So If we look at the first presidential decree, which we consider as the first, actually 1994, this was the first comprehensive document, although it didn't cover many areas, but it specifically named corruption as a problem. As a measure to tackle corruption, this 1994 ordinance required running of open, transparent trials to expose corruption. It also aimed at consolidating lawfulness and law and order. In addition, it also encouraged more active role in taking on corruption and fighting economic crime elements as a means of undermining financial resources for organized crime. So this ordinance actually, in this ordinance, the government recognized that corruption and other forms of economic crime, they serve as a source for organized crime, which at the time was more serious problem. So while the priority of the state at the time was the restoration of law and order and thwarting the external menaces, certain measures driven by the early statutory instruments counted for consolidation of the prospective anti-corruption framework. So when the law enforcement authorities demonstrated progress in the fight against crime, taking down organized criminal rings, it became apparent that the bureaucracy had turned into the primary habitat of arbitrariness and corruption. So after the first initial successes since 1994, in the next step, the government aimed at dismantling the legacy of the former Soviet Union, which was the bloated machinery of financial supervisory and law enforcement apparatus, which acted as a leech on the nascent and emerging entrepreneurship. And in order to do this, the Executive Order of 1996 on setting into order the state oversight in the field of productions, service, financial credit activity, and banning and grounding inquiries was adopted. The measures which were taken at the initial stage, such as sporadic restricting of financial inquiries and centralizing financial investigations by law enforcement, didn't seem to be a proportionate response to challenges in this field, and we know that specifically these challenges, they bred corruption. In the course of reforms undertaken according to Ordinance 1996, the government identified and scrapped several parallel and repetitive financial control and examination mechanisms. Soon it became apparent that further positive results were contingent on deeper reforms. These reforms, which had been taken until that time, they were not necessary, and in order to remove barriers to building market economy and especially hurdles to foreign investments, which were considered as a foundation for building sustainable economy, government had to take more drastic and dramatic measures. And according to the proclaimed position, tackling corruption stipulated achievements of these specific targets. In the next step, and as you will see, I'm jumping from the measure taken in 1998 to measure adopted in the 1999, as you will see that this 1999 ordinance is wider in its scope, and the 1998 decree actually is a bit narrower in its scope, but it is still very significant. The Presidential Ordinance of 1999 on streamlining state oversight system and removal of artificial barriers to the development of entrepreneurship identified bribery and red tape, especially the occasions of these types of behavior, demonstrated in the course of ungrounded financial examinations, registration and incorporation of legal persons, as well as licensing as burning problems. Please pay attention that initially they were presented as problems which undermined, which served as a source of economic crime. In this ordinance, we will see that they are actually put forward as burning problems which are serving as challenges to the entirety of the society. In an attempt to curb abuse of office by the law enforcement officials, the Ordinance 1999 actually prescribed centralization of parallel investigations. So the government set up a register for criminal financial investigations, and this register actually meant that law enforcement agents, they had to coordinate the launching of criminal investigations with financial institutions. And by financial institutions, I mean the bank regulator and tax authority. So effectively, without the endorsement of these financial institutions, no criminal investigation into financial activity would be possible at the time. As you see, the sporadic and discretionary activity of law enforcement agencies pose legal problems because law enforcement agencies were really affected by corruption at the time. The ordinance specifically came at the time when the economy of Azerbaijan saw steady investments, the flow of which was diminished and occasionally interrupted by unjustified interferences and abuse of office by public officials. So when the foreign companies came to Azerbaijan in order to invest money, these officials started to build problems, to ask for facilitation payments, and we know that facilitation payments are the payments which are demanded and extorted by public officials in order to perform their regular functions. So they would actually make problems to foreign investors in order to extract money for the type of job which they were obliged to do in line with their statutory duties. And this kind of agencies and bodies, they included the financial regulators, the law enforcement, and all types of these auditing agencies. And apart from the private sector interferences, the reform also addressed the abuses in public sector. In order to streamline the control of public spendings, the government scrapped the supervisory and auditing units in all public institutions and left public financial control as the task only with the Ministry of Finance. And we know that the tax regulation developed at the time, so the ministry, the tax authority took control of the taxation. It's apparent that in the course of a few years, the concept of corruption widened enough in order to merit addressing in its own right. If previously it was considered as a type of misbehavior emanating from organized criminal activity or a type of a criminal economic crime, now it was considered as a self-standing, as an independent problem. So duplication of control mechanism, prolongation of the terms of auditing and criminal investigation, complicating of administrative procedures, abuse of power in the communication with entrepreneurs, especially foreign businesses, addressing of social, civil disputes within the framework of criminal proceedings, all of these were perceived as the type of and manifestation of corruption behavior. You know, it would be a usual practice at the time when the people will address the unscrupulous entrepreneurs and businessmen would take their problems, their economic problems, to law enforcement and use all these mechanisms available to law enforcement agencies in order to resolve their problems, and quite often not in a very honest and just manner. I would like to specifically speak about this decree of 1998. It was an important development in the field of fighting against corruption. It spelled out economic crimes and corruption, especially such a form as abuse of office, as predicate to money laundering. Although it tackled the specific instances of corrupt behavior and economic offenses, it actually demonstrated the will of the government to address corruption not as an isolated type of criminal behavior. This ordinance reflected the approach of the government to treat corruption as a crime committed at large scale and generating illegal funds, and therefore resulting in subsequent offenses of money laundering and undermining the fragile process of setting up the legitimate market economy. As a result of these measures, the authorities managed to stabilize the situation, diminish red tape to sensible proportions. I mean, not significantly like to normal situation, but to sensible proportions, and raise awareness. This was the most important thing. They managed to raise awareness about corruption in the society. With the bureaucracy harnessed to a certain degree, an economy resuscitated mainly at the cost of foreign aid, the law and order was established, and the state administration policy didn't have to handling these existential threats, which I meant to you when the criminal gangs and were posing a threat to the statehood, and the war and aggression was stopped at the time. So the internal stability allowed to focus on more serious problems. The analysis of crime statistics showed that the level of serious crime dropped by 30%, and violent crimes and fatality dropped almost twice in the years 1994 to 1993 to 2003. So if you look at the numbers, the number of registered offences in 1993 were more than 18,000. It dropped up to years 2000 to 13,000. Although later we will see that it actually grew, but it doesn't appear in this table. But actually, the level of the economic crime, it actually had a completely different dynamics. So while the level, as you see, of the serious crime, it was more than 3,500 in 1993. It actually went down to 3,000. It actually, the number of serious crimes started to develop at the cost of economic crimes. So it doesn't appear on this statistical table, but you can find it in the official statistics published by the government of Azerbaijan in the Special Agency for Statistics. You will see that the crimes against person actually diminished and the economic crimes actually augmented. So this number, which you can see here, of 4,000 and more than 4,000 and a half, it actually reflects the number of greater proportion of economic crimes. This picture reflects the number of serious crimes of typical forms, such as crimes against person and health of people. As you see, as I told, this was not reflected in the table, but in this graph you can see that the number of serious crimes actually dramatically dropped from years 1993 to year 2002. the level actually of fraud offenses, which you can find in the statistical data of Azerbaijani government, you will see that the level of fraud offenses, actually the number of fraud offenses tripled in the same period. And if we look at the economic situation in the country, the agricultural sector, which shrinked in years 1919 to 2000, started to grow since 2000. And this was due to successful efforts of the government. And it only, please note that the agricultural sector reached the level of 1990s only in 2015. So it took 25 years after restoration of independence to come back to the same level of the agriculture. And since 2000, the international donors such as World Bank, EU, they started to invest in the non-oil sector. The growth level and of the productivity in the years of 2000 to 2008 was 16%. So this actually correcting of situation, resolvation of situation with existential challenges, and managing to bring the corruption situation to sensible proportions, it led actually to the influx of the foreign investments. The corruption took a stage as the ultimate challenge facing society by year 2000. The new presidential order of 2000 on intensification of fighting against corruption specifically targeted corruption as the main problem for further economic development, foreign investments, adequate public procurement, proper usage of natural resources, and other social and economical benefits. It actually built on the results of the preceding measures, of the preceding ordinances, including the good process of building framework for tackling economic crimes. And this instrument, actually, this ordinance, reflected the new economic reality of Azerbaijan, where the private sector by far started to dominate the public sector in the economy. And this ordinance actually remains the only legislative instrument which reflects the illicit enrichment as a form of corruption. Illicit enrichment now is not criminalized in Azerbaijan yet. It's under consideration, but no measures have been taken to criminalize this type of behavior. The authorities expressed their political will to tackle corruption in its own right. That's the main significance of this instrument, and not only as a part and parcel of the economic crime or organized crime. Among others, the ordinance envisaged the development of specific founding statute and action plan to fight against corruption. So it was specifically formulated that the particular act has to be elaborated and adopted, and the action plan has to be formulated. But despite the time limit of 6 months allowed for the development of these instruments, this process took actually 4 years. This might also be indicative of the position that this ordinance of 2000, it outpaced the existing level of understanding of corruption. The matter of fact is that the authorities extended their vision of the concept of corruption to include the abuse of power in the regulatory and supervisory institutions, cover such behavior as misconduct of officials with a view to gain not only material but non-material benefits. It also covered such behavior as misappropriation of property and wealth of the state, unfair competition, and concealment of income. It also depicted the corruption as flawed state financial control of an undue, inadequate control of public expenses. With this in mind, we have put the stage for the we come to the point when anti-corruption took its strategic stage. The starting point for systemic and sustainable anti-corruption efforts is going back to year 2004. It is in this year that the principal legislation in this field was adopted. Previously, the anti-corruption measures defining the position of government in defining the concept of corruption and filling in the content of anti-corruption measures, they were promulgated by the secondary legislation. At this stage, the government, the state of Azerbaijan, they started to adopt statutes. The specific measures formulated in the presidential ordinances, they developed into the strategies and action plans, and the general framework of this strategic stage of 2004 to 2015 is defined by the Anti-Corruption Act and adopted strategies. In the Anti-Corruption Act, which, as you see, I put in square brackets Framework Act because that reflects its actual situation. In this act, by this act actually, the government intended to define the standard for prevention and detection of corruption. Corruption was defined as an indispensable element of building welfare state and building social justice, protect human rights and freedoms, and secure sustainable economic development. As a legislative foundation, this Anti-Corruption Act 2004, which became effective as of 1st January 2005, it defined the systemic, coordinated, targeted and sustainable actions aiming fight against corruption. It actually hinges on the targets of lawfulness, transparency and effectiveness of state institutions. Municipal bodies and officials. The Act accentuates on the behavior of people that should be regulated and punished in order to tackle against corruption. If you look at the structure of this Act, you will see that it actually, let us switch to the side, it is actually composed of 4 chapters. The general provisions, prevention of corruption, corruption violations and liability, and handling of its consequences. Let me mention, before I go into the depth of this legislation, that it was meant to be a legislative foundation for the subsequent acts, but the level and weight of impact of this act on the subsequent legislative and institutional measures is hard to measure and even harder to demonstrate, as the country achieved the necessary level of European standards for systemic and public consultations on bills and adoption procedures in Parliament only in recent years. You will see that only a small part of this act is dedicated to the definition of substance of corruption, while the most part of it is dedicated to institutional arrangements, description of violations and their perpetrators, as well as consequences of corrupt behavior. In addition, more symbolically, rather than functionally, the statute obliges all officials of the state institutions and self-governing bodies to fight against corruption within their competences. Of course, we know that it's a kind of declaration which reflects the will of the government. And in addition to the list of officials who can be held liable for corruption behavior, and the list of types of such behavior, the Act actually describes few anti-corruption measures. These measures cover certain aspects of asset declaration, gift rules, and prevention of conflicts of interest, as well as, you see here, the whistleblower protection measures. For its own time, it actually contained very progressive elements of compensating of illegal gains. Also, it defines that all these acts which are adopted with a violation of anti-corruption rules has to be scrapped. The importance, as I mentioned, of this act, and I also mentioned it in the beginning of our lecture, that it contains a definition of corruption. So corruption shall mean illicit obtaining by an official of material and other values, privileges and advantages. It's one element. By using for that purpose of his or her of his position. Another element, or his status or the status of the body that he represents, or his official powers, or the opportunities deriving from the status and powers, as well as bribery of an official by illicit offering, promising, or giving him or her by individuals or legal persons of the said material or other values, privileges, and advantages. It actually is reminiscent of the definition of criminal offenses of bribery and abuse of office. And we realize that such an approach, if accepted, it will actually constrain the definition of corruption. And subsequently, the Act actually in itself, it tries to improve the situation through adopting such measures as introducing the concept of corruption violations, i.e. behavior which is actually corrupt or is actually it's conducive to corruption. And you can find this type of definitions in the Act, and you will see that there is actually classification. The Act defines different types of actions, behaviors into corruption offenses or offenses conducive to corruption. There's no criteria actually why the legislator defined this, classifies and attaches these types of behavior to these two different groups. And as we will see later in the if you look in the chronology of further anti-corruption measures, we will see that this division, this classification wasn't taken further. It's not clear how it was meant to be implemented, and it didn't actually affect it in any other subsequent act. Once only the Anti-Corruption Act was referred to in the Penal Code, and later on in the course of 2011 reforms, this reference to the Anti-Corruption Act in the Penal Code 2000 was eliminated. Otherwise, all the norms which are reflected in the Anti-Corruption Act, they are not supported with the statutory provisions which will foresee and envisage the violation of the provisions. As you see, unfortunately, this version of Windows is not quite original. I have to apologize for that, but that's the environment in which we have to operate. And at this point, I'm breaking I'm making a short break. So I'm continuing for the second part. Actually, it's in line with the breaks which we're usually doing during our normal lectures at the university. So we're going back to the Anti-Corruption Act. The adoption of this act actually inaugurated the formal record of targeted anti-corruption efforts in Azerbaijan. the authorities started to develop and launched the first anti-corruption triennial action plan at this time. Since the anti-corruption measures are implemented in the format, since then the anti-corruption measures are implemented in the forms of different types of strategies and plans. Within this strategic period, actually several documents which were adopted, and there's a difference between the strategy and action plan. As you know, while the strategy describes the conceptual issues and approaches, as well as set general standards and goals, the very specific measures aimed at reaching the goals and abiding by the standards are actually set in the action plan. It's difficult to judge which document actually is a strategy or action plan. So nominally, just for the purpose of this lecture, I suggested that within this period there were 2 anti-corruption strategies and 3 anti-corruption action plans were adopted. The first one, the National Anti-Corruption Action Plan, can also be actually considered as a strategy plus anti-corruption action plan, and the second one is a national strategy on increasing transparency and adoption, and an anti-corruption strategy which was adopted in 2007, with the subsequent action plans which covered the span of the years from 2007 to 2011 and from 2012 to 2015. The overview of these anti-corruption strategies and programs, it casts light on the issue of this understanding of corruption and defines it through the measures which were aimed at tackling this phenomenon through the set of regulatory and administrative measures. Through these measures, the authorities drew on achievements and good practices of the previous years, as I mentioned, and streamlined various initiatives which were conducted separately by government, civil society, and international stakeholders into a single process. Within the review mechanism of the United Nations Convention Against Corruption, it was specified that anti-corruption strategies in Azerbaijan could provide a comprehensive policy framework for actions taken by the state. There was a very useful and good piece of research conducted by the UNODC and a pool of experts, and this pool of experts signifies that although it's not an obligation, as it was mentioned in our previous lectures, to adopt this anti-corruption strategy and plan, but it would actually be a better framework, better driving force behind the anti-corruption efforts. The anti-corruption strategies in Azerbaijan, and especially the process of the collective elaboration, wider involvement of civil society in surveying the efficiency and awareness raising, as well as political support for the at the highest level, these were actually acknowledged by the international reports. You can find these type of reports in the internet, amongst them the report by the Istanbul Action Plan of the Anti-Corruption Network for Eastern Europe and Central Asia of the Organization of Economic Cooperation and Development, OECD. If we move on and look at the first National Anti-Corruption Action Plan 2004 to 2009, it was introduced by the executive order of the President. The document is composed of 2 parts. The 2 parts, first one setting the conceptual basis akin to the strategic overview, and the second one is listing specific practical measures. And it contained very important measures which served as a starting point, such as setting up the specialized anti-corruption agencies. It also provided for such important measures as harmonization of legislation first of all with Anti-Corruption Act 2004, as well as other international instruments. It specifically referred to the requirements of international instruments defining certain types of corruption behavior, and it requires the implementation of these provisions in national legislation. I shall point that among measures which contributed to differentiating of this stage of development of this anti-corruption strategic planning was the initiatives which were taken at the international level. So in 2003, Azerbaijan signed and ratified Criminal Law Convention on Corruption and Civil Law Convention on Corruption. These both conventions are conventions adopted within the framework of Council of Europe. They became effective in respect of Azerbaijan on the 1st of July 2004. Again, as I mention all the time, it's not important to remember these dates, but just for your information, for you to put this up in your head and to have a vision of the measures taken in Azerbaijan. In the next year, in 2005, Azerbaijan signed and ratified United Nations Convention Against Corruption, and it actually informed the Secretary General about the ratification of this convention on the 1st of November 2005. That was actually before the convention entered into effect on the 14th December 2005. Azerbaijan, as a result of signing of these instruments and also joining to the various frameworks, Azerbaijan is under the effect of UN review mechanism, which is called UNCAC IRG, International Review Group for the United Nations Convention Against Corruption, and the corresponding reviewing mechanism of the Council of Europe, which is GRECO, which is a French abbreviation for the Group of States Against Corruption. Furthermore, Azerbaijan is also under review by the Istanbul Action Plan of the Anti-Corruption Network of the OECD. These developments profoundly affected and shaped the process of conceptualization of corruption in Azerbaijan, as well as filling in the content of strategic anti-corruption planning and set of measures. It defined the anti-corruption policy, the transparency of the state administration in Azerbaijan. If we go back to the National Anti-Corruption Plan of 2004 to 2006, we'll see that it hinges on the principles of lawfulness, transparency, supervision of state agencies. It's important to understand that this strategic document, for the first time, it introduced the concept which was still new at the time. Yes, corruption was mentioned several times. The government took necessary measures to raise awareness in the society, to make the society seeing it as a concern, but still the concept was quite new for the society at the time, and therefore the government took the approach of pinning on the concepts which were already understood in the society. So the society knew about the lawfulness, they knew that the transparency is important, The state agency has to show how they operate, and as I mentioned, due to the rampant um, um, arbitrariness of bloated machinery, state machinery of state agencies, they had to be supervised and coached. Importantly, the measures formulated in the action plan, they actually transcended the reign of the criminal law. So from this moment on, corruption was not linked to the domain, to the area of criminal law. Corruption was not seen as a type of criminal behavior, but it actually transcended, it surpassed the boundaries of criminal law into the areas such as finance, public administration, socio-economical spheres. The concept of corruption stretched out not only through the legislative, but through a set of the other regulatory and practical measures. As a result of the implementation of this first anti-corruption action plan, Azerbaijan set up its anti-corruption institutions for the prevention and law enforcement, as you know, in accordance with the UNCAC provisions. The Commission on Combating Corruption, established in accordance with Section 4 of the Anti-Corruption Act, it mainly acted as a specialized agency in the field of prevention of corruption. It started to develop state policies on corruption, and coordinated the activity of public institutions in this area. And the Anti-Corruption Department, which is currently Directorate with the Prosecutor General, was set up as by the executive order of the President as a specialized anti-corruption law enforcement agency, a kind of autonomous prosecutorial anti-corruption agency entrusted with limited functions in the field of prevention and mainly entrusted with the criminal investigation of corruption offenses, including exercising of specialized investigations means such as wiretapping, etc., and other police functions. Most importantly, in 2006, corruption offenses saw significant, the concept of corruption offenses saw significant development in penal code. The definitions of crimes were substantially upgraded. The definition of an official expanded to cover a variety of functionaries in both public and private sector, mainly in charge of managing, controlling, and disposing assets. These people were considered as officials that can be prosecuted for corruption offenses. Such concepts as offer, promise, acceptance of offer and promise of a bribe, trade in interest were criminalized by introduction of the corresponding sections in the penal code. Such a considerable expansion of the corruption offenses, it took place within the framework of implementation of the international instruments at the recommendation of the experts. The subsequent anti-corruption strategy, a national strategy on increasing transparency and anti-corruption. It had two action plans, as I mentioned, covering different years from 2007 to 2011 and the next years of 2012 to 2015. As you can see from the title, of these instruments, the authorities try to insulate corruption from the domain of the general framework previously tied to the concepts of lawfulness, supervision, and transparency. If previously corruption was set as general framework linked to these concepts which I just mentioned, the government tried to put corruption into a compartment along with the concept of transparency. Transparency, what did the government meant by this term? Transparency actually is a term belonging to the concept of good governance. So corruption was presented on a par along with the concept which signified good governance. So as we see, there was a considerable change from the previous strategy. When fight against corruption was set as a general framework, now fight against corruption had to share the stage with the concept of good governance, which was introduced by the name of transparency. According to classical explanation, good governance has 8 major characteristics. It has to be participatory, consensus-oriented, accountable, transparent, responsive, effective and efficient, equitable and inclusive, and it has to follow the rule of law. It assures that corruption is minimized, the views of minorities are taken into account, and that voices of the most vulnerable people in the society are heard in the course of decision-making. Finally, it's also responsive to the present and future needs of society. So coming back to this strategic anti-corruption planning instrument, we can see that transparency came to serve now as the general framework. It pushed corruption into the corner and coined it as a kind of unlawful practice and behavior which is worth of punishing and being suppressed due to breaching all the actions which are aiming to make the society and state institutions transparent. So whatever is actually menacing transparency is becoming considered as corruption. Corruption was limited in this strategic agenda as a type of activity of proofing of regulatory instruments when the elaborated legislative instruments are checked for corruption vulnerabilities and corruption risks. It was also aimed at raising the awareness and implementation of international instruments. So the main institutions actually who were charged with this type of activities, they had more tasks and more duties under the umbrella of transparency rather than umbrella of fight against corruption. When it comes to the National Anti-Corruption Action Plan for years 2012 to 2015, it was adopted parallel to the new initiative, which was called National Action Plan on Promotion of Open Government. We will come later to this concept of Open Government Initiative, which was launched at the time, and it actually provided a framework for greater reform in the governments. But coming back to the subject of our lecture, I can tell you that this new action plan continued the trend of the previous action plan, and while the traditional areas for fight against corruption that it listed were criminal investigation and prosecution, reviewing of grievances and applications of people and citizens, and including citizens, activity of specialized anti-corruption agencies, building of the adequate anti-money laundering regime, regulation of civil service and practice of these regulations such as recruitment, promotion, disciplining. This strategy also added such areas as professional conduct, prevention of conflict of interest, and named systemic violations which had to be dealt with. So the government actually continued its demarcation of transparency-bound measures through the establishment of one-stop shops. The concept of corruption was further pushed in the field of serious violations and conflict of interest and professional conduct rules, as well as criminal type of behaviors. You can note that at that time, it was the time when the government actually came with one of its most successful initiatives of the initiative which was realized within the framework of National Project on Delivery of Public Service, ASAN. ASAN comes to the One-Stop Shop initiative to deliver public services, and this ASAN actually was delivered under the umbrella of it was developed under the umbrella of not against fight against corruption, but it was developed under the umbrella of transparency. This actually gave the government good means and tools to develop this initiative of transparency further into the optimization and improvement of the work of public agencies. But after implementation of this strategic plan of which up until year 2015 comes the next stage of 2016. This year marks the position of the government when the authorities refrained from adopting a separate anti-corruption plan and confined the anti-corruption measures to a chapter in the National Action Plan for the promotion of open government. And the next such initiative was taken for the years 2016 to 2018, and this year the executive order introduced a new National Action Plan again. This action plan also contains a compartment specifically dedicated to the fight against corruption. It would be a far-fetched statement to say that the authorities try to further limit the scope of corruption, but it's clear that the intention of anti-corruption strategic planning in Azerbaijan is to concentrate main efforts to the domain of criminal and administrative law and a bit in the field of integrity. So we can see that government is concentrating the main efforts, targeting open government targets, goals, and in order to make it clear, these goals cover, the measures under the Open Government Initiative cover such measures as improvement of electronic services through the capabilities and use of electronic government portal, reduction of a number of official documents and certificates required by public institutions, etc., etc. Also, while such measures as further improvement of legislative databases, ensuring financial transparency, it also remains in the field of anti-corruption, but more it actually shifted to the open government field because, for example, the financial transparency has came to be associated with use of new technologies, and the government clearly put forward in understanding that correcting the efficiency of financial control is possible only through the introduction of the new information technologies, which as a side effect will also resolve the problem of corruption. Mainly, such measures were referred to the field of fight against corruption as recruitment and disciplining, as well as professional conduct of municipal officials, and increasing transparency and responsibility in the private sector. and etc., etc. So the national authorities actually abandoned the plans to develop separate anti-corruption strategies. It is, again, national anti-corruption measures are only a chapter in the new Open Government Initiative Action Plan 2020 to 2022. It will remain to be seen how effective this is, but the main purpose of our lecture was to show the position of the government authorities of Azerbaijan in the course of anti-corruption strategic planning. So in the conclusions we can tell, summarizing what have been said, that there's no specific definition of corruption in Azerbaijan. We know this, despite some attempt taken in the Anti-Corruption Act 2004. The concept of corruption develops, it's dynamic, it continues it grows and shrinks, and while it grows and shrinks, it also defines the content of anti-corruption measures. But we have seen certainly the evolution when the government started with executive orders, making specific measures, specific targeted measures. They moved to the more comprehensive documents and strategies and action plans, and the anti-corruption strategic planning, while it was a kind of general framework at the time, it started moving back to the covering only specific type of behavior. That's the end of our lecture, and thank you for your attention.